is on the scope of African space policy and their regulatory frameworks. So firstly, we'll discuss the method of developing national space policies. This will be, if you've been listening before in the last session, some of these things are going to be repetitive, but I'll just have to move through them as quick as possible. In developing the national space policy, firstly, the national policy provides a structured approach that covers the national space strategy, a national space law, and a national space organizational structure, and other national regulatory initiatives as needed by the state to fully participate in outer space. National policies and strategies need to be set up at government level to determine the approach to be taken by a country in outer space. These policies are important for identifying the priorities and main objectives of a country in outer space. This is what we just heard now. Julius' closing remarks, that a country must look at their own priorities and their own objectives and not cut and paste. And they also create more transparency, coordination, and predictability and security for private actors. So you would find that in a state, the departments themselves are doing the same work when they are regulating that has an aspect to regulation of space, but then they are not aware that they're actually doing all of these small little things. So these aspects need to be brought together and coordinated so that there can be some transparency and predictability. When this is done, then this creates some kind of security for private actors to want to take part in the space industry of a state. And obviously then this avoids fragmentation and duplication of efforts from the different actors. A national space strategy, it structures and harmonizes all measures required for development of outer space activities in the country. It takes advantage of the characteristics of the country for outer space activities if applicable. For instance, its geostrategic position. You know that countries that are along the equator are better positioned for launching. So if countries along the African equator would love to take up launching services, for instance, they'll be an ideal place. And the strategy also defines and allocates responsibility for which ministry will do what. I was saying earlier that in South Africa, we have the Department of Trade and Industry being the one that is responsible for policy and the one that houses the Space Council. And then you have the Department of Science and Innovation being the one that looks after the space agency and the strategy and programs of space in South Africa. So that definition and allocation of responsibilities makes things move smoothly, and they create a synergy between the ministries. And the space strategy also increases awareness on the importance of outer space activities and calls on all relevant stakeholders to participate in the space efforts of the country. The stakeholders are the most important in creating in a strategy. They are the most important because they give the foundation. They are the ones that give space the foundation. Basically, are the reasons why we have space law, because it's these stakeholders that need to understand and come to the table to assist government to make these laws and to ensure that these laws can be implemented and enforced. The scope of regulatory framework in national space laws. National space laws are central instruments in investing in space. At national level, they reflect the provisions of the UN space treaties and regulate national space activities. and usually contain provisions on authorization, supervision, registration, and liability. And they're helpful in the development of space activities, products, and services at national level. The legal framework is informed by 5 UN space treaties that address the most important aspects of outer space activity. We already know the Outer Space Treaty. We have the Rescue Agreement. We have the Convention on International Liability that we just discussed. And we have the registration of objects, which we call the Registration Convention. And then we have the Moot Agreement. Just briefly, the Outer Space Treaty, it talks about the exploration and use of outer space, including the moon and other celestial bodies. That this shall be carried out for the benefit and in the interest of all countries. We have discussed this, so I will just move on to the important sections. Okay, yes, the Rescue Agreement also elaborates on elements of Articles 4 and Article 8 of the Outer Space Treaty, that no weapons must be placed in the moon, no weapons of mass destruction. And it provides that states shall take all possible steps to rescue and assist astronauts in distress and promptly return them home to the launching states. That states shall, upon request, provide assistance to launching states in recovering space objects that return to Earth outside the territory of the launching state. Then we have the Registration Convention that provides for all the outer space objects that are launched to be registered. They must be registered by the states that is called the launching state. The launching states can be in different categories. We have a state that launches, state that procures the launch, and the state from whose territory or facility an object is launched. So all these 3 categories fulfill the title of a launching state. Next slide, please. And then we have the Liability Convention that says that launching states are internationally liable for damages caused by a space object. This is taken from Article 6 of the Outer Space Treaty. There are 2 categories of liability according to the criteria of the location of the damage. We have absolute liability. This is for damage on the surface of the Earth or to the aircraft in flight, and false liability for damage that is caused elsewhere than on the surface of the Earth. And this is usually damage that takes place in outer space, in a collision between the satellites, for instance. That will be determined on a false liability basis. And then we have the Moon Agreement that provides that the moon and other celestial bodies should be used exclusively for peaceful purposes, that their environment should not be disrupted, that the United Nations should be informed of the location and purpose of any station established on these bodies, and provides that the moon and its natural resources are a common heritage of mankind, and that an international regime should be established. The common heritage principle is the most controversial, as you've heard when you were discussing earlier. It's the issue of balancing conflicts, balancing interests. I think we've touched on that, so I will not go over it. But then what informs our national laws? We have the Committee on the Peaceful Uses of Outer Space that also informs our laws partly. This committee was set up by the UN General Assembly in 1959 to govern the exploration and use of space for the benefit of all humanity. It has 2 bodies, the Scientific and Technical Subcommittee and the Legal Subcommittee that were both established in 1961. So countries that ratify the Outer Space Treaty and the other treaties on space are encouraged to take part in these committees, in the committee itself and the subcommittee, so that they can also have an input on what is done in space. So when devising a national space law, a country shall look both at its goals when approving a space law, as well as international trends. The law itself must respond to the growth of private space activities and the new trends in space activities. If you look at the Outer Space Treaty, it was really meant to govern the activities of state parties. It didn't, I think they didn't contemplate at the time that private entities would be able to want to explore space and manufacture and launch objects into outer space. So right now, the national laws that are established have to take this into consideration and factor in that their legislation must be enabling to the private entity. Possible deterrents are liability. The issue of liability, because launching is risky and expensive. We have already discussed this. So yeah, so excessive liability would deter the entrepreneurial creativity necessary to further the development of outer space. So moreover, government policies of fostering the emergence of private space launch industry will be frustrated. So it's important that as we look to the risks that are involved, we do not put a lot of burden on the space entities that are trying to also engage in space. For instance, you would find that in order to compensate for this liability, some states would require the space entity to take up insurance, and the cap for that insurance is so high, such that these small entities are not able to afford such insurance. So it's important that the states are able to balance this issue of liability and insurance for itself. And if you look to different states, you'll find that states are applying different methods of doing this, of applying insurance and liability to its space entity. But mostly the important activity that needs to be insured against liability is the space objects. Then there's the third-party liability and the government facilities themselves. So to ensure the successful development of the competitive domestic launch industry, there is a need for regulations to apportion launch liability risk between domestic commercial launch industry and the government, and provide incentives for certain satellite manufacturers. If we look at the example of Nigeria, for example, Nigeria established the National Space Research and Development Agency in 1999, and their policy and program were approved in 2001. The act serves to establish the agency, among other things, the encouragement of and capacity building in space science technology development and management, and to develop satellite technology for various applications and for related matters. An explicit function of the agency is to develop national strategies for the exploitation of outer space and make these part of the overall national development strategies, and implement strategies for promoting private sector participation in space industry. Furthering such strategies, moreover, the agency can now grant license to any person of body corporate for activities stated in the Act. This is their way of involving the private sector. And to also enable their legislation, the Nigerian government established a three-tier approach on insurance. Firstly, that the insurance of the lives in sea will reimburse the government at $5 million as the first tier, and then followed by 15 million as the second tier. But where now the government, where the damage is about 15 million, the government will accept upfront that the state will carry such liability without recourse to the licensee or his insurance. So